trial today, and that is what I came here prepared 100% for a trial today for the VPO. I am going to ask for a continuance and ask that we push the telecom harassment out for a few months because I do want to retain counsel. I'm going to sell my father's Mustang and retain counsel. So it's going to take me at least a little while, and I'm in school right now at C-Tech for 5G broadband. So and it's already paid for. I've already put $2,200. This case is over here. My life doesn't stop. I've got kids. I got child support. I have to work, and I got to go to school. So I'm asking that my graduation is after March 20th. We've pushed this out this long. I ask that if we do the telephone harassment, that we do that one past March 21st, so I can graduate. As for the VPO, I would like to make an oral motion right now and agree to your waiver to counsel for myself, and I don't need appointed counsel. I will represent myself on a separate matter of the VPO, and let me get the case number for you, Your Honor, for the record. Do you want me to stand on this, Your Honor?
You don't need to stand when you address the court. That's all right.
I would like the case number 23 CRB 1774A to note that I will represent myself on the VPO.
Okay.
And that I am going to request today as well an oral motion of dismissal because I was under the impression of a trial today. I am prepared for trial. If state is not prepared for trial today, I ask that they withdraw and dismiss.
All right, Ms. Yeager?
Your Honor, Mr. Bishop speaks prematurely about our preparedness. However,
So because you thought today was your trial and brought zero proof to back it up, we're just supposed to cancel everything and let you walk? That's not how this works, buddy. And definitely not how the law bends. He's facing serious charges, but acting like a misused calendar invite is a get-out-of-court-free card. I mean, you could see on the prosecutor's face here. She's pretty much done playing around with this guy, and judging by her tone too, she's ready to unload the full weight of this case. This isn't even confusion anymore, it just feels like strategy, and it's a very bad one at that.
in speaking with court staff yesterday, we were instructed to call off our witnesses for the VPO case. So we would be unable to proceed, but we did that based on the impression that this matter would not be going forward today. Regarding...
Objection.
You have to let her talk, Mr. Bishop.
Regarding the pushing the telecommunications harassment case to after March, we would object to that. These cases are from 2023. This has already gone on long enough. The defendant has a right to a fair trial, but the victims also have a right to a speedy trial as well. So we would object to just pushing that just so that he can graduate and sell his father's Mustang. Those are things that he should have already been prepared for. And since he did mention a disorderly conduct, we did want to just clarify for everyone, the state's offer has never been for a disorderly conduct. The state's offer has always been plead to the telecommunications harassment, and we would dismiss the protection order violation case. That's still what our offer is. However, if we do go to trial, we will be prepared to go to trial on both. Thank you.
Your Honor, that didn't address my motion to dismiss.
And we are not dismissing.
Well, I was going to say, she doesn't really have to address it if she doesn't want to, but... Okay, as far as your indication, Mr. Bishop, that you wish to waive your right to counsel in the 23 CRB 1774 case, I just need to go over this with you on the record in open court. You do have the right to be represented by a counsel of your choosing, by hiring somebody. You have the right to apply for court-appointed counsel, which you've done, and which the court has granted on numerous occasions in this particular matter. Obviously, the court was declaring a constructive waiver of counsel, but if you're affirmatively waiving that, we just need to put that on the record and have you sign off on it. Be advised, representing yourself exposes you to a number of pitfalls and dangers. Self-representation is never more recommended by any court that I've ever known because laypersons do not always know exactly how the law works or what the law is, what procedure is, but you would be held to the exact same standard as somebody who was trained and who was licensed to practice law. Do you understand that?
Yes, Your Honor.
And as far as that's the protection order case, right?
Yes, Your Honor.
Yeah. As far as that's concerned, is it your decision to waive your right to counsel and to represent yourself? All right, I'm going to have the bailiff present you with the form entitled waiver of counsel. If that is indeed your decision, make sure you go ahead and sign off on that, please.
For the record, Your Honor, it does state on that paperwork the maximum penalty. We've never went over that.
Okay, just to let you know, on both of these charges, the telecommunication harassment and the violation of protection order charges, they're first-degree misdemeanors. Each carry up to 180 days in jail, up to a $1,000 fine. They're also both what we call enhanceable offenses, which means if you were to plead guilty or be convicted of either of them, if you were charged with the same offense that you were convicted of here in municipal court, it could be filed as a felony level offense and carry a potential prison term, but your exposure as the charges stand here in this court are up to 6 months and a $1,000 fine. Understand?
Yes.
All right. And the record should reflect that the court did advise the defendant after he signed, but does that change your decision to want to waive your right to counsel?
No, Your Honor.
On that case. Okay, so the court will
on
accept
that
the waiver.
case.
Okay. Well, I'll go ahead and I'll grant the motion to quash without objection from the defendant. The other motion was to either quash the subpoena ordering Magistrate Kokensparger to appear for purposes of testimony, or in the alternative, because he had some sort of a conflict this morning, allow him to appear in the afternoon. Do you want to speak to that, Mr. Bishop?
I would object to that. As the prosecution has already stated, we've pushed this matter out forever, and he is crucial for the VPO situation because of his November 7th, 2023 hearing. And he is a crucial, I believe the word is alibi to the, or notice of justice is what I read about.
Oh my gosh, dude is looking towards the prosecutor like she's his vocabulary coach. He just asked if alibi is the word he wants. I mean, this is just brutal to watch, guys. You can practically see her restraining the urge to roll her eyes. I mean, she's clearly done with him, and honestly, you can just tell the whole courtroom hates this guy. He's already burned through multiple public defenders, harassed them, and turned this whole thing into a slow-motion headache for the state. I mean, this isn't even a legal defense. I mean, this dude is literally just loitering in the courtroom. At some point, you've got to read the room and realize nobody's stepping in to save you from the mess you made, buddy.
Which is why I pushed for the enforcement. But yes, his testimony on that date is crucial to my case, and that is why I believe he should be subpoenaed, because I have a right to face my accusers. He is one of my accusers.
Well, actually, the accusation is that you made a phone call, not that, I mean, you can't, I suppose you could attack the validity of a protection order, whether it was actually in effect at the time, but relitigating whether it should have been granted is not on the table. That's not relevant to the determination about whether or not you violated it. So I'm going to grant the motion to quash at this time unless the defendant can show with more specificity the relevance that Magistrate Kokensparger holds to the violation of protection order charge. So, and I want to say this as well. I think you issued the subpoenas in the 1774 case. And that's the one it should have been, and I put these two motions in the wrong file. Okay, so I'm going to go ahead and I'm going to grant both of the motions to quash. As I said, you can reissue your subpoena for our next court date, but you'll have to show with some specificity why you believe that the magistrate has relevant testimony to provide.
Well, my question to that, Your Honor, is the validity of my audio that I'm presenting on our trial date, because that is...
Well, I wouldn't. Let me put it this way: if somebody subpoenaed my staff to produce a recording of court proceedings, I would not be the one who would authenticate it. It would be the person who created the recording. So again, this is something that you're going to have to figure out on your own, because I can't give you advice on how to proceed. But there is a means by which you can address the appropriate party to produce those materials. And again, that doesn't mean they're relevant, and that doesn't mean they're irrelevant, but it means you have to go about the proper channels and seek the proper sources for those things. All right?
All right, and then also final for my record, Your Honor, I would like open access to be able to speak with the prosecution. And so the VPO matter on case number 23 CRB 01774, since they are separate matters, I would like to be able to have that line of communication between me and the prosecution open as is usual custom standard.
Well, you'd be surprised how frequently the prosecution fails to respond to emails and phone messages from actually licensed attorneys. So I can't force them to talk to you anywhere other than inside the courtroom, other than responding to any pleadings that you file. Certainly you have the right to contact them to see if they're willing to speak with you, but they're not required to prior to trial.
Absolutely understood.
Okay?
Yeah.
Anything else?
No, Your Honor.
All right, very well. We're going to stand in recess, and notice of the new court dates will be going out. It would be the court's intention to
The telecom is the oldest one.
yeah, that was what the court was going to try first, was the telecommunication harassment. But as I mentioned, the state's more than welcome to file a motion to consolidate, but I'm not inclined to grant that because I do find that it would be prejudicial to the defendant.
Oh,
Okay?
Your Honor, one more thing, just since he asked about open access to the prosecutor.
Mm-hmm.
I believe I indicated to Mr. Bishop last time when we were here with Mr. Oteam, and my position on that still stands. I will speak to him in court on the record, or I can speak to him in writing through email, just so that there's no miscommunication and no issues on either side.
Okay, very well. Thank you very much. Court stands in recess.
Can I get the email?
Yes. I emailed you.
Let me know if you guys want to see a follow-up hearing on this clown, because he is definitely a character in court. Like, unintentionally entertaining, but also deeply exhausting to watch. I definitely would not be surprised if his next move is selling his dad's Mustang to hire a sixth lawyer who still can't stop him from talking himself straight into jail. I mean, some people just like this guy just refuse to accept reality. I mean, they really do believe the system's out to get them, when really they're just tripping over their own ego every step of the way. And let me know what you guys think. What do you think this says about the courts when people can just stretch cases out this long just by being difficult? I know he hasn't had any punishment yet, but I just can tell the judge is over this guy. I mean, judges do have to balance due process with not letting the courtroom become a stage for chaos, and honestly, that's pretty much no small task when you got this guy in the courtroom. But yeah, guys, let me know what you thought about the judge, and if he handled this fairly. I thought he was pretty good, but I mean, this guy is literally on his sixth lawyer, so I mean, this is just getting out of control at this point. But yeah, guys, thank you so much for watching. I really appreciate it. Take care, everyone.